So, not all assets are good assets. Hi, I'm Claire from the Yanowitz Law Firm, where we've been helping families when a loved one passes away now for over 30 years. And today I'm going to talk to you about when loved ones pass away, sometimes they have certain assets that they own that are just really annoying to have at the time of death. And so I want to talk to you more about that in this video today. So, first asset that I see that is sometimes really annoying at death is timeshares. They can trigger probate in another state. Sometimes they can be expensive to dispose of, and sometimes the remaining family members don't really want to use them, but they really have trouble getting rid of them. I find that it is generally a lot easier to get rid of these when someone is alive, when the owner is alive, than at the time of death. They're also really hard to value. If you need to file an estate tax return, it's hard to get an agreed upon valuation on these. So these are something that if you bought a timeshare long ago and you're not using it anymore, it's best to get rid of it instead of holding on to it, because at death, it just becomes a worse issue. Another asset that is difficult to own at the time of death is interest in a closely held business that isn't really going anywhere. So we've represented people and their friend is having a business and they say, why don't you be an investor in my business? I'll give you 2 shares. And so they fork over $35,000 and they're a shareholder in this closely held business. And at the time of death, it's in total disarray. People aren't following the rules of governance for the entity. It's hard to value. It's hard to get paid out. It's not worth a whole lot. And so this just becomes a little bit of a nightmare at the time of someone's death. In this case, where you have a business not worth a whole lot and you don't really want to own it anymore, better to dispose of that prior to death than to hold on to it until death. Third thing to consider is sometimes I've worked on estates where someone has 20 different bank accounts. They have 30 different IRAs. And so they just have like lots of accounts. And there isn't like any real logic behind having all of these accounts. They've just done it because over time, maybe they wanted to open at this bank and then there was a new reason to open at that bank, but they never closed at the first bank. And so they have all these accounts that have $200 in them. And so maybe the estate is pretty small, but it still is a lot more work for your family to administer because they've got to talk to 15 different banks and close 30 different accounts. And so there's a lot more paperwork involved. So I recommend, if it makes sense from your financial point of view, to consolidate your accounts so that there's less accounts that have to be managed and closed upon passing. And generally speaking, it's easier to close accounts during your lifetime than at death. So better to take care of that now and have less accounts to deal with. Thanks so much for your attention today. If you have any questions about estate planning, we're always here to help. We give free consultations to new clients. Just give us a call at 507-252-8997, and we'd be happy to speak with you and learn more about your situation and how we can help. Thanks.